apologize for the slight delay in starting the meeting, but all of our meetings are important, but this is especially an important one, and I wanted as many of the board members to be in place as possible. Could I first get approval of the minutes from the previous meeting? So move. Is there a second? Second. Are there any questions or concerns about the minutes? All in favor of approving the minutes, please raise your hand. The minutes are approved. So at our last meeting, we talked about that at this meeting we would get more into what a public hearing should look like. But as I reflected on the meeting and as members of the city attorney's office reflected on the meeting, we thought it was time for us to go back and kind of have a 2.0 session. I mean, yes, at the very beginning of our meetings, we had all types of trainings. But as I heard some of the questions and concerns from various board members at the last meeting, I thought a little refresher would be good as we go into this. And so I asked Laura Baker Morris, who's the general counsel for the city attorney, to prepare a presentation for us today. And as we go through, it will help clarify, except there was another recommendation from Mr. Furby, and I'm going to share some information that he sent me later. Several things came up about discipline and the FOP contract. So it was shared with me that truly the folks to come in and to go back over that with us would be two individuals, Wendy Cade and Chris Moses. One is from Labor Relations and one is from HR. And so, because again, I think that's going to be very important to our understanding about what we can and cannot do. So it's my plan at this point to reach out to them, to ask them to present at our January meeting. Not as much detail, today. They are the experts. They are the folks that work with the outside counsel for the city to actually negotiate the contract and are very, very engaged with the contract. Okay? So if there aren't any further questions or concerns, the floor is yours, Ms. Baker Morris.
Thank you, Chair Jackson. And good afternoon, everybody. I recognize most of the members here. It's been a while since I've been at the Civilian Police Review Board meetings. I hope that Robert and Tiara and Jeff have been good stewards on behalf of the City Attorney's Office, have been answering any questions that you have. I'm sure that they have. Thank you, Chair, for inviting me back. I had hoped to be here last month as well, but family emergency took me out of the country. But it did mean I was able to watch. So I do have an awareness of what you went through last time, both with the panel from our office as well as Dr. Jones's presentation. And so it's my intention to build off of those conversations from last week. So the beginning part of my presentation will have a little bit of repetition to it, but I'm not intending to go over everything that you heard a month ago, just to kind of refresh your memory as to what you had heard so that we can build off of it and move towards discussing what a public hearing would look like for the Civilian Police Review Board. I also wanted, just at the very beginning, frame why I'm here presenting in this way. It's my job here to help or to assist in providing legal guidance about what the charter and the city code and your bylaws and the rules and regulations and the Fraternal Order of Police collective bargaining agreement with the city, what they allow you to do. At the end of the day, however, you have been appointed for a reason. It's your board. You can take these recommendations and determine how best to implement them. And so I wanted to state that right out, that I'm not suggesting to you that you have to do it in a specific way, but I'm certainly suggesting to you, here's a way to do it that would be consistent with the authority that you've been granted and your duties and obligations on the board. I also please encourage you to ask any questions that you might have along the way. I, and as well as my colleagues, are more than happy to respond to any questions that you might have. So with that, investigation review training 2.0. So we'll go ahead and we will get started, because there's nothing better than a PowerPoint on a gloomy afternoon. Save. There we go. All right. So I was looking at Dr. Jones' presentation from last month, and I love that you had an agenda at the beginning. I thought that was a really great idea to let everybody know where we're going. And so sorry, I cribbed off of that and did kind of a similar thing. So the first thing I'm going to do is I'm going to start with a basic recap of what you learned last month. It's just going to be one slide to just remind you. Then I'm going to go back and explore the sources of your authority and the sources of your duties and obligations. So we're going to talk a little bit about the authority of the board, the hearing responsibilities of the board. Then we're going to get a little bit into the requirements of the collective bargaining agreement. As Chair Jackson already mentioned, I am not the expert on this. Those individuals hopefully will be here to speak with you in January, particularly regarding discipline. But it's really important as you do your work that you understand how this board's work interfaces with the requirements of the collective bargaining agreement. Because even though they are not your source material or source of authority, I should say, they are certainly binding upon the city, and they're certainly binding upon the officers whose work you are reviewing. So we're going to go over the ones that are relevant to your work. As you can see, I've only outlined Article 8 and Article 10. There are certainly many more articles within the collective bargaining agreement. It's a 150, 60-ish page document. It's pretty substantial. But these two sections in particular are relevant to the work you do here for the Civilian Police Review Board. And then building off of all of that foundational work, we're then going to talk about the hearings themselves. And I know last week you talked about how your subcommittees would get together and review the investigative packets from the Inspector General's office. And so hopefully those subcommittees have had an opportunity to meet and you've had time to discuss the particular investigations that you have been assigned. So now the question is, well, now that we've done that, what do we do with it next? And so we hope towards the end of this presentation to answer that question. What does a review hearing look like? What's the purpose of a review of investigations? What is the process by which the investigation review hearings can occur for this board? And what should that look like? And what should the expectation be? And once again, we're level setting for the very beginning of this. This is the first time you're ever going to have one. This thing might change and evolve over time. It certainly might evolve as the collective bargaining agreement is once again renegotiated over the years and as you develop familiarity and expertise. But you have to have a starting point, and the hope is that after this presentation you'll have at least a framework or a sense for what needs to happen next, and then you can develop off of that your specific practices and processes. Okay? Recap. All right. So Dr. Jones presented, as I said, last month and talked about the components of an investigation report. And I thought it was an excellent presentation. I have a copy of the PowerPoint from last time. And basically what you did was you talked about the investigation review itself. So the third thing that was really important to the board was to recall that this was not an investigation that you are yourself conducting, but that it's a review of an investigation that was conducted by the Department of the Inspector General and a specific individual from that department who was charged with investigating a particular matter. It was then suggested that you go through and use the investigation review worksheet in order to standardize how the subcommittees would be reviewing these particular investigations. And I know that a good amount of time was spent discussing what the purpose of the review sheet was and why it's important to have a very objective criteria in order to make sure that all members of the board have a voice in expressing their opinions about the investigation, but to also make sure that it is standardized and objective so that when you bring it back to the board has an expectation or an understanding of what you're trying to communicate to them. It was recommended that you be thorough and that you document your conclusions. And it was very much restated that your conclusion is what the disposition is as relates to the recommendation from the Department of the Inspector General. So you have a full investigation that's been conducted. You're reviewing it for that purpose to determine whether or not it was in fact the full investigation that you hoped it would be. And then once you have reviewed the investigation, it's about making a recommendation to the full board of what you ought to do regarding that particular matter. Do you agree with the findings of the Inspector General? Do you disagree with the findings? If you disagree, why? Are there concerns that are still unclear to you, or answers that have not been answered, or questions that have not been answered for you? And then you would, as a result of all of that, the subcommittee would then make a recommendation to the full board. And I wonder if there's a question about why that needs to occur that way, and I'm thinking that that might be the case. But I think it's important to remember that the board is a body and specifically enacted as a public body. So even though each of you are independently important as members of the board, you only act with one voice. You act as a board. So while it's important for purposes of efficiency, to be able to divide up the investigations in the first hand, it's also really important that the board as a whole is the one that's making a decision regarding any particular investigation. And so that's why we're going to focus on how do you do that, right? All right. Any questions so far? Okay. All right, we're going to go back to the source, the legal source, the source of authority for your actions and for your duties. And we're going to start with, if you remember back on September 7th of 2021, I was here before. It doesn't seem like it was that long ago, but it was, in fact, that long ago. And that was the initial presentation on the city charter and the Columbus City codes for this particular board. And some of you served also on the city advisory board, but this was the first one for the entire full actual appointed board. And we went through them then. I am not going to go through all of them again. So I just want you to know you've been spared that. But I did want to remind you that what we did talk about is the source first of the authority of the board itself. And so there are three major sources of law that inform your work as you operate. They are the city charter, the city code, specifically provisions 23501 and 23502, and then the bylaws you yourselves adopted, which now become rules by which you govern yourselves. And so we're not going to spend a lot of time on these because I think you know how you got here at this point. But I think it's always important to remember that because of that city charter, because of those city codes, you adopted bylaws. And within those bylaws, you specifically discussed procedural rules for your regular meetings and adoption, certification, and publication of rules and regulations, which include your rules for hearings. So when you think about how did we get to where we are in terms of now having a hearing in a particular way, it's emanating from all of these sources, and part of them are the sources that you yourselves created through your rules and regulations, which the city code and the city charter gave you the authority to do, okay? So again, back in September, we discussed, how you came to be composed. The thing that's important to remember about this provision of the city charter is just that majority of whom shall constitute a quorum. That just goes back to why are we doing this as a full board? It's contemplated by charter and by code that it's the full board that's acting, and that it's a quorum of that full board that's making determinations on investigative matters. Again, the city code provision that I mentioned, 23501, talk about terms of the boards, talk about all those kinds of things. Again, importance of being on the board and what your authority is. I said, we're not going to go through this. Just want you to remind you that it's there, and that's how you got to creating your own rules. And then, of course, the reference to the bylaws, which you should all be familiar with. You sleep with them, I'm sure, right by your bedside table. Read them before you go to bed. No, but they're important to recall that you all agreed as a body to act in a certain way, and so that's important objectively to those individuals from the citizens of Columbus who are coming to you with their complaints, and also from the officers' perspective as their work is evaluated, that you're going to abide by the rules that you yourselves created. So that's the source for your authority as a board. Now we move on to the source for your authority as pertains specifically to hearings, all right? So we're moving from one aspect of the creation of the board to the functions and duties of the board. Similarly, you're coming from three different sources: from the city charter, from the city code, and from the rules and regulations that you adopted. So we're going to talk a little bit about each one of those. Yes, I'm going to read all of this to you. I'm just kidding. So you go through and you talk about City Charter Section 216, powers and duties. Let's talk about the very first line, and this is kind of going to help hopefully clarify why we're doing what we're doing. The Civilian Police Review Board shall receive, initiate, cause investigation of, and recommend resolution of complaints. So if you're just getting to the very heart of what your authority is coming from our city's constitution, as we like to call the city charter, you have specific duties that have been given to you by the citizens of the city of Columbus when they voted on these charter amendments, and they are specific to receiving and initiating, and you discussed that in your rules and regulations. There were determinations made as to how you were going to use those powers, and in this case, within the rules and regulations, there are specific delegations to the Department of the Inspector General to perform some of those tasks. You also have rules and regulations that pertain to if somebody comes to you as a member and they say, I want to file a complaint, how are you going to deal with that? That's about initiating a complaint on behalf of the board as a whole. Well, it wouldn't be appropriate for just one member to do that. It would be appropriate for the board to do that. And what are our rules for doing that? They're in our rules and regulations. Obviously, if you as a board member see something, you can as a private citizen initiate, but we're talking about your function as a board. Then we talk about cause investigation of. I think it's important to note that the city charter does not contemplate the board itself conducting investigations. There are provisions within this that talk about you having a potential role in that, and that role is in the review process. So it is upon completion of an investigation, the board shall make recommendations to the Division of Police regarding resolution of the complaint, and where warranted by the facts, may make recommendations pertaining to discipline. And that's something that we're going to talk about towards the end. So when you take a look at Section 216, overall function of the board in this regard is to cause for an investigation to occur through the processes you've adopted through your rules and regulations. And then the most important aspect of your role is to recommend a resolution of that complaint. So you have before you the investigation completed by the Office of the Inspector General. You have oversight authority over that office. So part of that review is making sure that they have dotted their I's and crossed their T's. But then you also have from our charter the obligation to make the recommendation of how that complaint should be resolved. Should there be a finding that the officer did or did not violate policy? If the officer did violate policy, to what policies did that officer potentially violate? And what will your recommendation be to the chain of command? There are provisions in here that discuss the issuances of subpoenas. And so when it was written, it was contemplated that this would be a place where the Inspector General could go in the event that the Inspector General is having difficulty obtaining the information necessary. There is a process by which, through your rules and regulations, you have also given the Inspector General some authority to issue subpoenas or to ask for evidence pursuant to your rules and regs. And so fortunately, I don't think that's come up yet where we've had difficulty obtaining information, but it's important to note that it is here. But as we go through and start talking about the collective bargaining agreement, I want you to keep in the back of your mind what the purposes of those subpoenaed items might be. Because as we laid out in the first paragraph, your primary responsibility ultimately here is that review and recommendation. You might have a role to play in assisting the investigation regarding this issuance of a subpoena by the board. But when you are acting to assist in the investigation, then you are covered by a different part of the collective bargaining agreement. And that is going to implicate the timetable that you started to discuss last month. Okay? So I just want to put that out there right now, and it's the very last line of that second paragraph. I'm sorry, Kyle, I keep looking right behind you because it's the easiest one for me to read. Underlined and in red that subpoena power is specifically restricted by the terms of any collective bargaining agreement. So that's how it gets looped back into the FOP CBA. Yes, yeah.
So I guess what do you mean by that? Sorry, I'm just a
That's
little
all right.
bit further clarification in terms of like in what instances is it going to be limited and what does that mean exactly? Like, is there an example in particular that you're?
Let me give you an example.
Yeah.
So let's say that the Inspector General has a complaint that's been filed by a citizen and it's alleged to have taken place at a gas station. And the officer was wearing a body-worn camera, but the citizen is saying that, look, the camera doesn't give you the full angle on this. If you had the video from the gas station, you'd see what I'm telling you is true, that if you had the reverse angle. And let's say that the Inspector General then went to the gas station and said, I'd like to get your video in order to review that for the administrative investigation. And the gas station says, I'm not doing anything unless we have a subpoena, okay? So now you have a scenario where information is potentially out there. The Inspector General has indicated as part of their investigation that they feel that the information is relevant and necessary. So it's not just something nice to have, but they think that it's actually important based upon what they've reviewed. So the question now is, what is the process going to be by which they could obtain that? Under your rules and regulations, you have delegated some authority to the Inspector General to potentially issue a subpoena. And we are still, within the City Attorney's Office, working on the process by which that could occur. Assume that that's happened, all right? So the Inspector General at that point, once that process does fully exist, will be able to go through and do it themselves under that process. But another way underneath the charter that that could happen is that the Inspector General could come to a meeting like this and say, I'm having difficulty with X, Y, and Z, and I'm going to ask the board to consider whether or not the board could seek to have a subpoena issued through the process that we're going to establish. That could also happen. But, and this is my caveat about the collective bargaining agreement, once the board is participating in that way, you are now part of the investigative process. You're no longer reviewing an investigation that's been concluded. You are now being pulled into and being asked to weigh in some way on the investigative process. If that is the case, then you are within the 90-day limit. Your actions are no longer actions that are outside of the 90-day limit, which means the Inspector General might make a determination, I can't really wait till the next board meeting, I'm going to run out of time, I might have to do it a different way. So I just wanted to really make clear that while the authority might be there, it's much more limited because of the collective bargaining agreement.
And so to retain that potential authority and make sure we're not diving in necessarily to the investigation, the idea would be, if possible, if we're able to kind of get this process set up and that the IG would be able to make that initial step without it implicating us in the broader.
That is the goal.
Okay. All right. Thank you.
That is the goal. All right, moving on to the next. Maybe not, there we go. So we had the charter that set out the broad parameters of your responsibilities, and then we had the provisions of the city code that laid out the specific duties of the board. Again, I'm not going to go through all of these. I want to just focus in on the ones that pertain to the board hearing function. And those would be the ones that I've conveniently highlighted with blue. So number one, to receive, initiate, review, again, and if appropriate, to direct the Inspector General to investigate and prepare a report for review. So the primary function there is, again, receiving, initiating. You've taken care of that through your rules and regulations. Review is what we're going to be doing. And if appropriate, to direct the Inspector General to investigate and prepare a report for review. That would be, of course, if something comes to you rather than coming to specifically to the Inspector General, you might be able to refer them through the processes that you've created through your rules and regulations. The third one down there is to make recommendations on resolutions of complaints, and that's what we're going to discuss through our hearing process. Geez. Same thing, number 4, to make recommendations on discipline regarding the outcome of all investigations. We're going to talk a little bit about that towards the end. So the rules and regulations that I've been referring to, these are the ones that you adopted. And they also have a specific provisions that pertain to how you're going to function. The board may create subcommittee groups made up of 3 or 5 members to conduct the initial review, and all of you have now been divided into those groups for those purposes. The subcommittees will then report out to the full board. We're going to discuss what that looks like, and then indicate whether the subcommittee agrees with the recommendation drafted by the IG or requests a hearing on the contents of the report. All right? So a hearing may be held following the affirmative vote of a majority of the board, and if a majority of the board agrees, then they shall forward it on. Yes.
Can I interrupt you for just a moment?
Yes, of course.
And in essence, it's to, and I'll say apologize to the subcommittees. I should have recalled and given you notice at the last meeting that these subcommittee meetings and any committee meeting really of the board is considered open to the public. And so you have to go through that process of, once you choose your date and time of location, or reaching out to Bethany, who can then advertise it. And I think we got it all together this time, but it wasn't without some hiccups. But we just need to remember, if it's any committee, it is subject to we're a public body. I'm sure we find that challenging. I do. But it's the way we have to operate. And I don't know if you've been having any problems in terms of finding locations to hold your meetings. And again, thinking about the fact that, someone from the public may show up. I have just noticed recently that our public libraries have great meeting space. That could be a place, you may have others, but it is something you will have to pay attention to going forward.
If I could, this came up within our committee as well, and I spoke with Mr. Tobias about what would allow us to have virtual meetings, because from a volume perspective, 6-8 months from now, we don't know how many reports we're going to be looking at and how frequently we're going to have to get together as our small reports. Apparently, there is an issue 21 that was passed, which starting in January will allow, if approved by city council ordinance.
Bingo.
Yes, right. No, I'm getting there. My point is at some point today to make a motion that we as a board, provided everyone agrees, ask to pass an ordinance via city council, or at least propose it, so that we could have virtual meetings, because at some point, I imagine the volume might be unwieldy, and they can still be public and still be publicized. The link just has to be made available for anyone who wants to come and, watch virtually, but I think that might help with coordinating schedules moving forward.
I think it certainly would. That's good to hear.
Yes.
It's good to hear.
And everything you said is absolutely correct.
Good. So sorry for the interruption,
No,
but I
no.
want to clarify that.
And I think
Yeah.
a couple other questions came up, too.
Yeah, it's along those lines, like trying to get a sense of how we're going to divvy this up, and we're going to get into more details once we have the conversation. I am the one concern I have about kind of the way in which we're doing kind of the subcommittees and breaking them up and then having them as public meetings is that I'm just trying to get a sense of like a process in place for when people come to those public meetings, especially if, let's say, they're involved in they issued a complaint. I don't know how they know who's going to be reviewing their particular complaint, but I mean, in theory, right, you could show up to one of these meetings in which, you have review members who are discussing somebody's case right here, right in front of them. So I wasn't sure if we had a process for that in place, or best practices for that in place. I completely understand in the context of us having this kind of meeting with the full board, the full body here, but the worry that I have is just additional potential for the lack of us to speak as one voice when we're in situations as a subcommittee and we haven't figured out what those standards and procedures are. If somebody comes in and is watching what we're going to decide on the review, we're not doing the investigation, we are reviewing the checklist of the active investigation that's going on. So that's one of the things I just had an open question for.
Let's put a pin in it
Okay.
a little bit later. Yeah, I will just quickly say from my perspective, I can understand you being uncomfortable. There are 3 of you in a space, somewhere someone shows up. I mean, my first thing is simply saying to the person it's inappropriate for any comments or whatever. But there could be, for example, a very unruly person where your personal safety, you may be concerned about that. So let's come back and I don't know if there's a
I can,
Laura?
I do have, again, it's your board and make the decisions, but I can say that some of the boards and commissions that function out of the zoning area, what they do is they have a standard meeting, like BZA has a standard meeting, but then they also have what they call a business meeting. And so they set aside a specific period of time where anything that might end up on the official agenda on the following meeting might be discussed in the business meeting. It's still an open meeting. It's still subject to all the requirements. But the benefit of that is that if you chose to go that route, you could set all your subcommittee meetings into the business meeting day. And so that you would have like one location where there might be multiple sub-meetings meeting. That's one way to go. There are lots of ways to do this. But the way that they handle does everybody know when it's being reviewed, is that they don't necessarily have a specific agenda for the business meeting day. They'll just be like, the business meeting agenda will be things that might appear on the following meeting. But for the actual board meeting itself, when they have appeals or they hear variances, their agenda actually does contain the reports that they're reviewing so that people know that it's coming. And so, again, it's up to all of you, how do you want to do that, but that's one way another board has done it.
Okay.
All right. I forgot where I'm at. All right, we're going on. So the public hearing provision of the rules and regulations talk about a good faith effort shall be made to hold public hearings within 30 to 45 days of the board's request. So let's put all of this together. What this all contemplates as I read through the city charter, the city code, and your rules and regs, is that essentially you're going to have an initiation of a complaint in a variety of ways, but all of them are going to eventually be funneled to the Inspector General's office, right? That's where all of them are going to really begin. The Inspector General is then going to conduct their investigation. Once they receive it, once it's filed with the city, they have 90 days to do so. So they're going to do what they need to do to investigate their particular matter. At some point, they're going to determine that the matter is fully investigated. They've gone through their policies, practices, and procedures. They've interviewed the witnesses that are appropriate. They've gained the evidence they feel they can gain. And they have then submitted that entire complete investigation to the Civilian Police Review Board. Once they do that, the 90 days stops, okay? So for those of you who practice in court, it's like the time is told. For those of you that don't practice in court, think about like in a football game that it's a timeout, right? The time stops from that point, but any time that investigation is going to happen again, it's like the game clock is running again, all right? You, within the Civilian Police Review Board, and we're going to go through where this authority comes from in the collective bargaining agreement, you are within the timeout period. All right? So long as you are reviewing it, you're in the timeout period. If you were to request additional investigation and that is within your power to do so, then the game clock starts running again on the 90 days. So investigation hits the Civilian Police Review Board. It goes to the chair. The chair makes a determination as to which committee or subcommittee, I should say, is going to be assigned to. You conduct your review as a subcommittee. You then refer your completed review back to the chair, and as I understand to Bethany as well, that's where that laid out at the end of last meeting. And then it gets set on an agenda for review by the full board, right? But that review by the full board, while part of that review process, is not necessarily a hearing on that particular matter. It's not a full hearing, let's put it that way. There is the possibility within all of these provisions for actually have a full hearing. So I'm going to move on to talk about what that kind of looks like and when you get to that point. But before we do, I swear, it's like the big buildup to the final exciting thing. We have to talk about these provisions of the collective bargaining agreement because it's going to inform why I'm going to make the recommendations that I make regarding the full hearing. And so this is Article 8 involving investigations under the collective bargaining agreement for the Fraternal Order of Police. As you can see, I've written out all 17 sub-articles that are contained within Article 8. But the ones that are highlighted in hot pink are the ones that are specifically relevant to the work that you're doing and that we're going to cover a little bit here today. Okay? Article 8, Section 1. This is what gives the Inspector General's office the authority to conduct these internal investigations that didn't exist prior to the collective bargaining agreement with the FOP being renegotiated by the city in light of the citizen vote for your existence. So because that happened, that is what caused that continued conversation to happen and ultimately resulting in the amendments to 8.1. So 8.1 discusses when an officer who is a member of the Fraternal Order of Police is going to be investigated for an allegation of wrongdoing of some sort. And it says that internal investigations shall be conducted by the chain of command, by the Equal Employment Opportunity Office, by personnel assigned to the Internal Affairs Bureau and/or the Office of the Inspector General. And again, it's a lot of different entities that might be able to conduct that investigation. It depends greatly upon what the nature of the investigation is. But predominantly for the kinds of experiences and concerns that we're just talking about here today, most of the things that you are concerned about are, of course, being investigated by the Office of the Inspector General. There might still be some things that are investigated by the Internal Affairs. Definitely, chain of command is going to get some of your investigations after review by the board. And then the Equal Employment Opportunity Office is separate and apart. It's really dealing with employment and labor relations, employment issues within the within the Division of Police. I can't speak at all. So when the OIG conducts an internal administrative investigation, and that's the officer of the Inspector General, they shall have the authority to compel attendance and participation in an interview under threat of insubordination or like offense. So what you're going to find as you walk through Article 8 is that there are some very specific obligations upon the inspector to behave in a certain way in conducting the investigation. And it's important to keep these things in mind because sometimes questions will arise during the review by the Civilian Police Review Board. Why can't we do this? Why can't we do that? Well, some of it pertains to what's specifically been bargained for by the city with the FOP regarding how an investigation is going to be conducted. And the Office of the Inspector General has become fully versed in that contract, and they are absolutely aware of what their obligations are. And so sometimes when you ask about something, that's what we're thinking in the back of our head, and that's hopefully what Chris Moses and Wendy Kane will be talking with you a little bit about in the month of January as well. But you need to be aware that they're out there. 8.5, investigation questioning. And again, I'm not going to read through all of this, but this is once again to talk about why this is important. Because I imagine that the question might come up from the Civilian Police Review Board at some point during a particular investigation. Why can't we just order the officer in here so we can ask that officer questions about this incident? I imagine that's in the back of your mind. And the reason that that would be a difficult thing to do, if not near impossible, is because some of the provisions here in Article 8.5, members of the Fraternal Order of Police have bargained for and have obtained specific rights under Article 8.5. Members shall be fairly apprised. Members shall be informed. Members shall be investigated in a particular way. A member shall only be asked questions in a specific way. And we certainly don't want to occasion the city walking into an unfair labor practice by compelling the testimony of an officer before the Civilian Police Review Board there where that questioning may not comply with Article 8.5. So that's one thing to consider. Is that? Yeah.
Question because
Yeah.
this kind of came up when we were going through and reviewing the reports that we had.
Yeah.
Now, although we would not want to have that practice within our full board, does the IG have the right, if they feel necessary, to ask for an interview with officers involving a particular complaint?
Do they have the right to ask? Yes, they do.
Okay.
Yes, yes. So the reason that an inspector general may ever hesitate not to interview an officer would be as if there was an ongoing criminal investigation. But generally speaking, most of the time, the inspector general will not have the administrative review going on while the criminal investigation is still ongoing. So there are garrity rights, which I'm sure you've heard discussed already previously, that we want to make sure that once we compel their testimony, that information they provide could not be used against them in a subsequent criminal matter. And so there might be a reason to wait. And so it could be, for instance, that an inspector general staff member has made a decision not to interview an officer for a particular reason. But absent those concerns, they are able, pursuant to 8.5, to bring an officer in and interview them regarding a matter. Again, it's a matter of discretion whether or not they choose necessarily to do so or not. Right? Yes.
On that point, I mean, do we have any sense of, I don't know, and maybe we can get to this later, but like what the practice is, what we've started to determine a sense of that, because I think, just to your point, it seems like you don't want to get in situations unnecessarily where you've got to compel somebody and, you're trying to figure out ways to voluntarily get this information without it. So I'm
Right.
just,
And I'm now getting into the area where I should defer to the
Got it.
inspector
Okay.
general.
Yeah. All right.
So I would say that, yes, there are practices.
Got it.
Oh, come on. Again, going off of 8.5, there are also specific requirements relating to how you conduct an interview. So let's assume for the moment that an interview is going to be set up with a member who is a subject of the investigation. There are also very specific rules regarding how those interviews are to be conducted. They are to be any interrogating, questioning, or interviewing of a member will be conducted insofar as practical at hours reasonably related to the member's shift, preferably during the member's working hours. Interrogation, questioning, or interviewing shall be reasonable periods of time, shall be allowed questioning attendance due to physical, they can stop to go to the restroom, basically. If at any time during the interview the investigator believes the filing of a criminal complaint against the member may result, then the member shall be so informed and shall have the right, if requested, to consult with the lodge representatives. In other words, they have very specific rights bargained for under the contract that pertain into how that interview might be conducted. And so that's one of the things we have to be concerned about if there was a question about, well, can't we just bring the officer in before the board, right? Complaints themselves. So I'm going to actually have to go to the side. All right. So Article 8, Section 12 governs the filing of complaints, and of course this is now how the Inspector General and Civilian Police Review Board policies, practices, and procedures feed into the collective bargaining agreement. In order for a citizen complaint, including an anonymous complaint, to be investigated, the complaint must be received by the city in writing or reduced to writing within 90 days after the date of the alleged event. So that was the first 90 days that was discussed during the last meeting. So you have an incident, within 90 days of that incident, it must be received by the city in writing. There are some exceptions. Those exceptions relate to allegations of conduct that are criminal on their face, allegations that can reasonably lead to criminal prosecution, et cetera. So for instance, if you have a police-involved shooting, and there is a complaint related to the police-involved shooting, but that shooting is under investigation by the Bureau of Criminal Investigation to determine whether or not criminal charges will be filed. That is an event that will be a tolling event for that 90 days. Okay? But if absent those kinds of exceptions, and there are some other ones down there in tiny little print, that's because they're not really relevant to the work we do here, that they do exist, and I didn't want to leave them out. But absent that, I think for your purposes, you should be thinking if it's coming to you, it's probably that 90-day window that had to have occurred, okay? Not always, but probably. That will be whether or not it gets into the door to the Inspector General, right? So if there are individuals, for instance, who want to complain about an incident, and file a complaint, I should say, not complain, file a complaint about an incident that occurred 2 years ago, and none of those exceptions apply, and they go down to the Inspector General's office to file a complaint, that Inspector General's office, one of their triaging will be to determine whether or not it's within the 90 days as required by Article 8, number 12. Okay? Are those being brought to the board too, or are they being resolved at the IG?
No, if we can't investigate them, they're just closed.
They're just closed, okay. So the ones that are determined to be outside of that 90-day window without an exception are being closed at the Inspector General's office, okay? But you should know that it's out there because sometimes that becomes a question along the way. Can I still investigate this? All right, did you have a question? Yeah.
I think it might be helpful too, and like for later reports, just for us to be aware, we don't have to go through the whole investigation review process, but if we're ever at any point where we're seeing patterns of people filing, complaints that are outside the time window, just so that we, from a public awareness perspective, might be able to address that. That's helpful. Thank you. And then I did have a quick question.
Yeah.
Does this apply? Is one of the exceptions as well non-citizen complaints? I saw some language.
So, yeah, non-citizen complaints are generally complaints about officers by another officer, and have another specific provisions that are applicable that I am not as familiar with.
Okay.
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 But most of the ones that you're going to be looking with are going to be citizen-generated complaints.
Okay.
Yeah.
Thank you.
Right. And that actually, your question brings up one other issue. So right now, today, we're talking about the board's responsibilities related to hearings as the primary subject. I think it is important to keep in mind that that's only one aspect of the overall duties of the board. And what we're not discussing here today are the duties of the board pertaining to practices, policies, and recommendations that you might be able to make. So those are certainly things that are still important to the board and to the board function. And I'm not trying to not emphasize them, but it's more that this particular topic is just about the hearing. But they still exist outside of and can certainly be informed by the things that you're learning from these investigations. Investigation outcome. The investigation of a citizen complaint shall be conducted within 90 days after the date the complaint was received by the city. Right? And an investigation will be considered concluded on the date that it is initially forwarded to the chain of command and or the Civilian Police Review Board. So we've got two sets of 90 days. The one we talked about on the prior slide, which is how long the individual citizen has to get that complaint to the city, with some exceptions. And then once it's in the hands of the Inspector General's office, they have 90 days to complete the investigation. Right? Now, it's important to think about that. 90 days total. So again, go back to the football analogy, right? They have that period of time, the clock is running so long as they are continuing their investigation. Once they have made a determination that their investigation has been concluded and they have filed it with the Civilian Police Review Board, the time clock stops. If they have days remaining, so let's assume that an incident occurred 30 days ago and that the incident was clear, either pro or against the officer, but that it was clear what happened, and they conclude within 30 days. The time will stop the minute that they submit it for your full review. If you then, as a board, determine, wait a minute, it's not that clear cut at all, we think there are concerns that maybe you missed or that you overlooked and that we'd like you to look into, let's just assume that that happens. They might have the opportunity, assuming that those other pieces of evidence actually exist, and sometimes they don't, and sometimes they do. They might have the opportunity to do that because there are still 60 days remaining on the investigation clock. On the other hand, if the particular incident was complex, if there was a number of officers that needed to be interviewed, a number of citizens, they were difficult to track down, or the volume at the Inspector General's office is simply high, such that each officer is, doing a number of investigations, and by the time that they complete, they're on day 89, right? And they bring it to the Civilian Police Review Board for review. The time stops at day 89. You decide, hey, there's some additional information I might have. They only have 1 day left, okay? Now, there are ways to get more time. There are provisions within the collective bargaining agreement where you can seek the agreement of the union to extend time for particular purposes. The union has done that in the past under certain circumstances. The union has also not done that in the past under certain circumstances. So I don't want to tell you that there isn't a possibility, but I do want you to be aware that the best practice is, of course, to follow the specific provisions of the 90 days plus 90 days. If there are extenuating circumstances, then the best thing to do would be to contact either Robert or Tiara and to talk with them about what those extenuating circumstances might be so that we can then work with the individuals that would be necessary to reach out to the union to determine whether or not a time extension would be appropriate or would be granted by them, okay? But it's this provision of the article that really informs the time frame that the Inspector General has and how much time they have to get it to you. So, as I stated at the beginning, once it comes to you and you're conducting your review, if you take a look down at the very bottom line, the last one that's highlighted down in blue, it says the 90-day limit shall not apply to any chain of command and or the Civilian Police Review Board review. So long as you are conducting your review, and that would include your subcommittee reviews as well as the review by the full board, as well as if you were to have a full hearing on a particular investigative matter, that is not within the 90 days. The clock has stopped and you're in the timeout period. Okay, and you have the time to do that. But once you yourselves engage in activity that might constitute investigation, that's when the question is whether or not that clock's going to start back up again. And definitely, if you send it back to the Inspector General to conduct additional investigation, which you have the ability to do, you have to be mindful that they only have whatever time they have left on that 90 days to do that. Right? Any questions about that?
It's not a question.
Yeah.
And I was just looking at the forms as they come from the IG's office. I'm thinking it would be helpful to have it noted on the form how many days are left. And so, IG, we want that to be a part of what you send us, so it's very clear to us.
I have a question.
Yeah.
Just for clarity purposes. If BCI is still investigating, how does that affect that 90-day window? I just want to make sure we
Yeah,
got,
it hasn't started.
okay.
So when BCI is investigating and they're making a determination as to whether or not criminal charges ought to be filed, they fall within the exemption to the 90 days because it's reasonably, even if they don't end up charging, it's during that entire period of time where it's being investigated as a potential crime, during the period of time that it goes to the prosecutor's office, whether that be the municipal or county prosecutors, it's more often the county prosecutor's office, during the period of time where it's at the grand jury, all of that period of time is the 90 days doesn't even begin, okay? So,
Make sure we had clarity on that because there's been some confusion in my mind.
sure, it's confusing.
Yeah.
It's confusing. It's intended to make sure that the criminal investigation is not rushed, or nor that the administrative investigation in any way, shape, or form interferes with the transactions of the necessary criminal investigation. So it's basically, we're on a pause here. The clock's not even going to start to run until we've made the determination, yay or nay, that this individual is going to be is going to face criminal charges. If it's determined that they're going to face criminal charges, so there's an investigation, there's a grand jury indictment, and now there's actually a pending criminal case, then that administrative clock still hasn't started. All of that period of time where there's a criminal matter of any shape or form related to the incident, and it's not related to another incident, related to the specific incident that you're investigating, that would be an exemption from the 90 days.
Okay.
I had two quick questions. One, perhaps I missed it or you're getting to it, but I'm not clear about why we would conduct an investigation apart from the IG, and what the kind of matters would be that we would do. And what sort of resources we even have to conduct investigations. So it's just, yeah.
Yeah. So my job is to kind of lay out what authority you might have, and then it's your job as a board to make sense of that authority. And I think that when you take a look at the combination of the charter plus the code plus the collective bargaining agreement, they all kind of lead to the same conclusion, which is that investigators should do the investigating and the board should do the reviewing.
Yeah, I mean, that's what I would think, but I just, you've mentioned the parallel authority, and I'm just trying to understand why we would ever go down that other road.
And my recommendation would be that you not, for all the reasons that we've just expressed.
Right.
But I wanted to be completely transparent
Right.
about.
That we have that authority
that there are some
if
areas.
we chose to exercise it.
Right. And that the problem is that, I'm sorry?
I see a valid reason in wanting to actually have these investigations, again, presented in front of us if we severely disagree on, A, the investigator's decision tremendously, or we keep seeing the exact same investigator sending the exact same recommendations back. So I think that in that situation, I'd like to hear if we can bring the witnesses themselves or talk to the officer, et cetera, et cetera. I don't know what where we land on what we can and can't do there, to your point, but there is a valid reason for actually wanting to continue this investigation and not wanting to push it right through.
But if we are seeing, as board members and reviewing, we are seeing things like you just said, and maybe it's from a particular investigator, some challenges, then I believe it's the responsibility. We're going to find about it here, and it's my responsibility specifically as the board chair to have a conversation with the IG. So we're taking corrective actions, right? But the way to take that action is not to investigate, it's to address that matter.
Yeah, and I would just plus one to that because I think we don't, I personally, and I don't think we want to be in the business of investigating, right? And especially in terms of how we engage with the broader community and talk about these issues. Like, we want to make very clear that we are a review, kind of a review function. Now, when we get to the specifics of whether or not we think more needs to be done, we can still ask of the IG's office.
That's
and
our
whatnot,
investigative arm, is the IG. We're not in the business of
That's right,
investigating.
But again, I mean, I think it's helpful. We have the power in case there are other situations, and you should maybe use the power you have. But I don't think us being particular investigating, and it's similar of us asking for review.
Right. Agreed. And just keeping in mind that any power that is exerted, the collective bargaining agreement is still going to control. Right. So, okay, 90 days. We got that done. All right, requirements of the CBA. I'm going to move through this part a little bit more quickly. The Article 10, corrective disciplinary action. My point in going through these slides at all is just to inform you of how much there is out there. It's not to specifically have you be able to memorize or regurgitate all that's in here. I just want to make you fully aware of how much goes into whether or not an officer is or is not disciplined out of a particular action. And so when we talk about the authority of the board to make recommendations regarding discipline, it's very much with the understanding that you're not going to necessarily have all of the information necessary in order for any kind of recommendation to fall within all of the obligations and requirements of Article 10. And so I just want to put out there what those things are, just so to fully inform you of what is in there in the collective bargaining agreement. So in Article 10, 1 and 2, the most important takeaway is that no officer shall be disciplined except for just cause. And there's a definition of just cause. There's a body of case law regarding just cause. There's a prior past practice regarding what constitutes just cause. There are attorneys that do nothing but have their entire practice on what constitutes just cause. So each time that someone in the chain of command or the chief of police and the Department of Public Safety, safety director is making a decision about discipline, corrective discipline, they are doing it with that in their background and that in their understanding as to whether or not they can and cannot discipline for a particular behavior. The other thing to be keeping in mind is that the city, specifically pursuant to this contract, encourages the use of positive corrective actions. So that's a whole nother area that the chief and or the safety director would have to consider, and or the chain of command would have to consider for more minor violations, that positive corrective action is being affirmatively encouraged by the city for particular violations of practice. Article 10, progressive action. I think this was talked a little bit about. The principles of progressive corrective action shall be followed for conduct not in violation of law. So when the officer's behavior constitutes a violation of the standard operating procedures, but that violation does not constitute a violation of the law. So for instance, this might be things along the lines of use of foul language or being rude, things along those lines. Corrective discipline is specifically bargained for in the contract. So what you may not have as you're reviewing these things is the officer's prior history of discipline. And so you might find that something in front of you to be particularly egregious, but A, you don't have a comparison for other officers' behaviors and whether or not that's as egregious as other behaviors, and B, you don't have that current officer's prior history. So that's something to keep in mind. The chain of command, the chief of police and this director of public safety would be constrained by the need to use progressive corrective orders in order to address any misconduct. Responsibility for imposition of discipline. The decision to issue positive corrective action shall be made by the member's immediate supervisor, and the decision to issue corrective or disciplinary action or inaction, and the level of corrective or disciplinary action is subject to review by the chain of command. So that also is very specifically in the article. So while the Civilian Police Review Board certainly has the authority to state, we believe that this officer ought to be disciplined out of this behavior. Keep in mind that the actual decision about what discipline to use and the ability to actually issue that discipline is specifically reserved to the chain of command. Chief of Police, after charging a member, may make a recommendation to the Director of Public Safety as to the appropriate level of discipline. Then you further go down. And there's also the possibility, instead of taking some level of forfeiture of corrective action, but if they choose not to do that, then then the Chief of Police shall transmit the departmental charges to the Director of Public Safety. The purpose of having this all up here, again, is to kind of inform you of what happens to this thing after you're done with it. So you have gotten an investigative packet, your subcommittee has reviewed it, the full board has reviewed it, you've either had a hearing or not, which I swear we're still going to get to, and then you've made a determination it's going to end up with the chief of police. It's then going to follow this process. So if you're thinking about, where's the full hearing of this matter, it happens afterwards. So there's the chief of police is going to make a recommendation. There's the possibility of a full hearing on departmental charges before the public safety director. Those things have been bargained for and exist within Article 10 of the collective bargaining agreement. I'm really not going to read all of that. But
But could I stop you for
Yes.
just a moment? Physically, how do we do this? So we have these reports that we can sign off on, after we vote. We've done it.
Yep.
Literally, how does it get from us to the chief?
It's my understanding, and I'm going to defer to Tiara, who I believe was looking at this particular question, that it was going to be forwarded directly to the chief of police via,
Or the chief's designee, and it could be via email.
So is it like a?
yeah.
It really can be whatever way. That's not dictated by the contract, how the actual recommendations get to the chief. It's just that they get there. So if the chief recommends, per se, that DC Weiner is to receive all of the recommendations, and then they will review it in that way, that is fine. But that is an internal procedure that you all will work out with CPD. Whatever you work out is what's
So
going
is
to
this
be
something,
followed.
as for an example, and I don't know, would it be in the SOP, or this is just purely ours? I mean, like literally, if we get to it today, and there are decisions made, and I sign off, I mean, I'm being very procedural here.
So it-
Should there be a cover sheet somehow developed?
Again, that is something you should do, and that is something you would work out, and I would suggest that it be put in your procedures, reduced to writing in the board's procedures, because remember, the IG is sending you the recommendations, and then you all are recommending to the chain of command for CPD.
I have a question as well, and maybe I'm getting a little bit too far ahead, but then once they do go to the chief of police, how is the board going to be updated on the status of those reviews?
And another question, different but the same. How do we notify the complaining party of, should it be the board or the IG communicating with the complaining party once we've made a decision?
So the contract does dictate that the IG notify the complaining party, as well as the officer who is the focus of the investigation,
Okay.
once the investigation is complete. The IG has made a determination that she will also let the officer who is the focus of the investigation know that there may be a follow-up hearing that the Civilian Police Review Board decides to have. Again, that is going to be determined by you all. So the
Well,
IG is already going to let the officer know and the complainant know that the investigation piece is complete. But
So
that
for the
doesn't
cases
make
that we
the
have
process
right
complete.
now, the cases that we have that we haven't acted upon,
There have been closure
they've
letters
already been
sent.
notified?
Yep. Yes.
okay.
There are some, I was
And I'm sorry, I jumped in. I apologize, Dr. Jones.
This is okay, but there are some where I know specifically our subcommittee had some questions about the recommendations. We disagreed with a couple of them. And so how then do we know what happens after we disagree?
Quick supplement for I know to add part 9 to the question. I actually do think a cover sheet to the department that just kind of has a high level overview. If we send them, and we can obviously send them all the copies and whatnot, but of like the individual, everyone doing their review, because I know everybody did reviews, 3 people did a review of the same cases, all that. If we did that, I think it would be pretty overwhelming. And so a cover
And I
sheet.
was going to raise that issue. I thought that we had decided that each committee would come together and each member of the committee would have completed their thoughts. You then discuss it amongst yourselves, and then you produce one review, one, not getting all 3. That's not going to be helpful, and that's not how you came to your conclusion of what you're doing. And so I was going to raise that today when I heard from you, but, and I know for Pastor Nathan, that's what you did. You have one completed sheet coming from the subcommittee.
Yeah, we did it the right way.
We provide, so what we did, and so what I did is provided an overview, a general overview that doesn't go into the specific, because and we can talk about this, but there's a balance between micromanaging the type of the investigation that was done versus putting out the main concerns or challenges that we had versus that's kind of the balance of.
So
but
why
we can
don't,
talk
why
about
don't we hold that?
Yeah.
And try to move forward. And let me just share, because you're sitting here as board members saying, wait a minute, it is 3:15 and we're still going. I think that this is so important. I think that this review is so very, very important for us. So I don't know if we'll get to making decisions today. The best news I heard after last month's meeting is that when it comes to us, time's told. It's over. So, and I'm not saying we're going to sit on them because I'm already contemplating, can we have another meeting this month? Do we have 2 in January? But I just want us to be very comfortable with all of this as we go forward. And maybe answer some other questions about future, proceedings. Okay?
I have a question. And I'm not sure if that was already up there in that. When one of the board members is actually initiating the actual complaint, does it have to be done at a board meeting like this and someone else then has to second it, et cetera? Is that how those would be initiated through or for the IG's department?
That's what's in the.
Your bylaws have a process for the board actually initiating a complaint.
And you've
it
done
has to
that,
be the
you've
full
done
board.
that already for 3
Or
particular
3 other
complaints.
cases, correct? Okay.
And before Laura gets started, you all are asking a lot of questions about your procedures that aren't dictated by the law. So these are things Laura is going to explain to you the parameters of what you can do pursuant to what the law says. And then within that, you can develop your own procedure. So how a complaint gets to the chain of command, how a recommendation gets to the chain of command, all of that is within your procedural purview and your discretion.
Right.
What she said.
I second that.
May I ask a question?
Yes.
Yeah, I just need a little more of a clarification regarding the notification that's sent to the complainant. Once you've completed your investigation, does the IG immediately before it goes to the board for our review? Okay, so there's no notification to the complainant until we complete the process of our review, get it back to the IG, and then the complainant?
No. So
That's- so-
the IG, as I've understood it, the IG is notifying the complainant once the investigation has been completed and delivered to you. So at that point going forward, if there's going to be any notification to the complainant, it would have to come from the board because you now have it.
Okay, so is the decision made by the IG also included in the completion of this review of the investigation, or just we completed our investigation and forwarded it to the board?
Deferring to the IG.
That's all? Yeah. But you know nothing about exoneration or anything like that? So the actual resolution of it has not been communicated to the complainant?
Because you haven't decided yet.
Well, I'm just asking what the complainant gets.
The letters that are sent out to the officers state exactly that the investigations have been completed, but what the findings are, but the fact that it still has been moved on to the board.
So the officer actually gets the findings before we review it?
Yeah, and that is based on what the FOP has allowed for us to do. So we still have to be in compliance with the contract.
And what about the complainant? Does the complainant get the findings from the investigator or no?
Yes.
And is that required?
That's just, I don't believe that's required. That may just be a part of our policy since we're also notifying the officer is also to notify the complainant that the investigation has been completed and what our findings, but they still are advised that everything still goes to the board for the board's final review.
I just wonder if we might want to modify it if the if the collective bargaining agreement requires you to give the officer the findings, I get that. On the other hand, regarding the complainant, inasmuch as we're all reviewing the file, inasmuch as we're all reviewing the case before there's any ultimate resolution, it might be a bit disconcerting for a complainant to hear, my goodness, you know, I felt like I had a legitimate case, the officer was exonerated, we come back and we have a recommendation to you that is contrary to the investigators. I wonder if it might make more sense to say this stage of the, you know, of your particular case is that the investigation is complete. It's now forwarded to the Civilian Review Board. They will have, you know, a review of this and then forward it back to us. We will then give you, you know, a final determination of your particular case. Do you understand what I'm saying?
I think that I'm going to chime in for a second. Yeah. I don't think that's a good idea.
Okay.
But you obviously, as the board, can do whatever you like.
Sure.
But, you know, part of the goal is transparency. And just because your decision may differ from the IG's recommendation, that's okay. That's your role and function. But in terms of whatever the IG is concluding and recommending, that should be shared with the complainant.
So how many times, how many letters from the IG will be going out to the complainant and the officer? There'll be one at the end of their investigation when they forward to the board. Then at what other junction will a letter go out?
But the board is going to then refer any recommendations either to the chief of police, or if the board's making determination that the inspector general's recommendation of no referral is accurate, then it would go back to the IG. So not everything would go back to the IG. The only things that would go back is if you agree with the IG and the IG's recommendation was that the officer was not in violation. If you believe that the officer was in violation and you agree with the IG or disagree, but you believe the officer was in violation, it's going to the chain of command, to the chief of police.
And does the complainant then get
to
a copy of that disagreement, in as much as Mr. Furby is suggesting that we, for the sake of transparency, inform the complainant of all of the procedures that were, you know, all of the decisions that are made in their case?
Right, I mean, that's up to the board to decide how many notifications, but ultimately, all of the cases you're reviewing are going to be up for a full board vote.
Yeah. I would like to, maybe we can hold this, but I would like to recommend, with all deference to you, a different procedure. So, yeah.
Well, here's the thing. The officer is going to be made aware of what's happened, but the complaining the civilian witness, at what point will they know what the end result is? I mean, that's the issue that I'm wondering.
What the board will have to decide is when that matter is being held for a vote, should the complainant be notified of that in case they want to show up for the hearing?
So let's take this to the hearing itself, because I think you're asking some really important and relevant questions, but I think what it's showing is that the board has some decisions to make about your procedures and processes. So if I think, Chair, with your indulgence, if we talk about what that review would look like, that might then generate some additional discussion about what the board would like to have done, right? So I skipped 2 slides. You can go back and read them later. They're fascinating. But I wanted to get us to the review hearings themselves and talk first about what the purpose of the review by the full CRB. So you have had your subcommittees conduct the review. You've gone through your checklist. You've made your determination within the subcommittee about what you think ought to happen next. So what's the point of bringing it to the full board? Well, first of all, as we discussed earlier, it's only through the full board that you actually act. So those subcommittees are just there for administrative convenience and for efficiency purposes in order to get the matter to the full board. But it's the full board that needs to decide whether or not there was or was not a violation, and if so, what your recommendation is going to be. So essentially, you're hearing whether or not you agree with the recommendation or you disagree with the recommendation, and if you disagree, are you disagreeing because you believe that more investigation is needed, and what would that look like? Or if you disagree, are you disagreeing because you have internally within the board conflicting views about what you have read? So let's take your typical referral. Let's say that you had somebody who came in and made a complaint against a police officer on a specific date and indicated this officer was rude to me, this officer called me and specifically stated a name, all right? And let's say the Inspector General's office then took about investigating that, identified appropriately the officer that was involved in the incident, pulled the body cam video, pulled the the dash cam video, and the officer was like the most nicest human being you've ever in their entire lives, and it's clear from the video that they never said the name that the complainant alleged that they did. Okay, let's say that was the subcommittee review of the Inspector General report. They agreed with the process that the Inspector General's office went through. They recommend to the board, we don't feel that this officer should be disciplined. We don't feel that there was any evidence to support the allegation. Do you need a full hearing to do that? The answer is no. You could simply have the subcommittee, and we're going to talk about what that's going to look like, the subcommittee chair bring forward to the board, here's what the allegation was, here's what we reviewed, here's what we're recommending, here's why we're recommending it, and the board could simply vote and say, yeah, we agree with the Inspector General, this officer didn't do anything wrong, and you don't need to have a full hearing. It would be a full vote of the board. It would be the board weighing in on it, but it wouldn't be a hearing. Contrast that with you have a situation where a citizen is indicating in their complaint that an officer injured them during an arrest process, and they are indicating that the officer's behavior in taking them down to the ground was injurious to them, and you have two members of your subcommittee that believe that that officer's actions violated policy, and you have a third member of your subcommittee that says, no, I think that's clearly within policy. And you have an IG recommendation that's saying it is within policy, and then you have the subcommittee bringing that to the board, and everyone is like kind of on the fence about whether or not that behavior did or did not violate policy. That might be the kind of circumstance where you would want to have an actual full hearing before the board. So I think that you can have situations either both where everybody agrees the officer did do something wrong and you wouldn't necessarily need a hearing, or everybody agrees the officer didn't do anything wrong and therefore you don't really need a hearing. The determination about whether or not you do or don't is uniquely within your power. So you have subcommittees that are going to bring forward to you what the allegations are, and then you're going to take a vote about whether or not you need a hearing. So let's take a look at what that would look like. Let's assume that you have now with the second scenario, and you have indicated the board is kind of split, and you don't know whether or not you should agree with the Inspector General or not. You at that point in time, and again, your policies and procedures say that you're going to try to schedule a full hearing within 30 to 45 days of the time that you receive the investigation. So if you, for instance, at this meeting determine, hey, we have an incident that we feel we need to hear more from the Inspector General on, you could at this meeting schedule it for the next meeting, as an example. That's something that you could do. Or you could decide you want to pick a day when you have full hearings. That's completely within the board's choice in terms of how you want to do this. But you would set it for a date certain, and you would inform the Inspector General's office, we want a full hearing on this particular one. Ideally, and because the Inspector General's office is present for these hearings, you can inform them specifically what the nature of your concern is. Maybe the board is split on whether or not there's a violation of this particular provision of the directive, or this particular directive. Maybe the board is split on whether or not the IG's assertion that this particular witness was or was not credible, as an example. So you have a discussion when you're making your determination about whether or not you're going to have a full hearing, about why it is that you want a full hearing and what do you want out of it. You want the Inspector General to be able to come to you and present the information that underlied the investigation and to be able to answer questions. So that's the purpose of the full hearing, yeah.
Point of clarification about the full hearing. So let's say you have a subcommittee that conducts a review, and they agree that there was, so let's say that the Inspector General says that, such and such did not violate policy. However, the subcommittee identified another policy that was violated. However, the Inspector General did not cite that particular policy in the report. Would that be something that we would request a hearing on? Or could we just say, hey, did y'all consider this policy?
I see Tiara nodding over there. I don't know if that's been discussed previously in terms of identifying the particular.
I was going to say that would be something that you would refer back to the IG for further investigation and specify the other policy maybe that you believe was violated. That may have been overlooked, but not a hearing.
Okay,
Yeah,
perfect.
yeah.
Thank you.
And in doing so, just remember the timelines.
Right.
So I think that this is my question.
Yeah.
So when we look at it, if we send it back, they only have like 2 days? I mean, so for example, if it has come to us on day 88, if I've got my times, and they only have. No, okay.
I think they're
And-
controlling
And
it.
so literally, we want to send it back. Absolutely, it should be. But if they pretty much have run out of time, do we have options?
You do. So there is, again, the option that we request an extension, right, from the FOP, delineate all the reasons in which you would need that extension. Under contract, they are not to be unreasonably withholding extensions, but again, that should not be our ordinary course of business, right? We're trying to finish things within timeline. But this is brand new. These are your first set of reviews. I think that if that's going to be the case, that's something that we all discuss, you discuss with our office, and we help you get that drafted and get it submitted in due time.
Theoretically, though, for a scenario like that where there's another policy that just wasn't noted, this is a violation, but it looks like it's a violation, that could also be a hearing as well
Yes.
instead of a return, right? So if we're up against a deadline, that could be, we have a hearing, somebody comes in, reads a policy on the record, and then that could be how we resolve rather than sending back for additional investigation.
Yes, I think in theory it could. Just remember, I mean, if you're doing additional fact finding, that is going to be considered investigation. You're going to be under whatever time remains from that 90-day timeline that has already been taken. But if you're having a hearing and you want clarity on, the parameters of a directive or something like that, I think that can be done in order to
Right, and if all
prevent
the,
sending it back to the IG.
if all the facts had already been collected,
Yes.
but the issue is whether or not a particular
Yes. Right.
applied, then you're not doing additional
Right.
fact-finding, but you are identifying additional potential
Yes,
violations.
we're in the same committee, so
Yeah, okay,
that's,
okay, got it.
that's all it is.
Got
Like,
it, got
we're
it.
just trying
And
to
some of
get
this is going to
to.
be, in the beginning, kind of the back and forth in terms of your establishing your relationship with their office about what the board is hoping to see and versus not. And some of so everything I'm laying out here is kind of just to give you an idea, but as we've kind of stated a couple different times, ultimately, as a board, you're going to decide how it is that you want to conduct yourselves in terms of doing these hearings. My recommendation is that smaller things can be done just simply through board votes and discussions. So if there's simply a matter of clarifying, maybe it's as simple as the IG knows exactly the investigation you're referring to and could say, yes, we considered that, but here's the problem with that particular provision. It doesn't apply when the officer does X, Y, and Z. It might be as simple as that. I don't know. I don't know the facts, but it could be. In which case, that wouldn't require a hearing. That would just be more about clarifying as to why we thought what we did or didn't do. But clearly, as you're having your discussions about each one of the investigations that's being brought to the full board for review and for discussion, it's going to become clear some things cannot be resolved simply by discussion because there really are questions that you're having inherently about what happened in the investigation itself. That's the kind of thing that you might want to set for a full hearing. And so it would then be saying, next time, we want to hear from the Inspector General and/or her designee, because she might say, well, it would be more appropriate for the investigating inspector to come in and present to the board, and that individual would then be able to come and discuss with the board, here's what I observed, here's what and take questions, because that's the big difference, right? When you're doing a review in your subcommittees, you're reviewing paper and you're reviewing collections of persons' memories and of their responses to specific incidents as they've written them down on paper. And that might raise for you questions, not because there's anything wrong inherently with the investigation, but that you're simply a matter of interpreting what they're telling you. And so sometimes you can resolve those things if they're small, simply by board discussion with the Inspector General. That's why the Inspector General is here for these board meetings. And other times it becomes more of a matter of, no, we really understand what happened. We just disagree about what it means. And that's the kind of thing where you might be wanting to then have a full hearing, where that information is brought out so board members can ask questions about it. So if that were to be the case, then what you would want to do is that the chair would run the hearing. And again, this is an administrative recommendation ultimately at the end of this. So even though we're thinking about it in a quasi-judicial, I heard that come up, a kind of fashion, we're not the ultimate determiners. This still is administrative in function. So you're going to respond like a board would, and that means that the chair is going to run the hearing. The chair will recognize the chair of the subcommittee who brought forward that particular investigation. That subcommittee chair, speak, will then give a brief overview of what case is this, who are the relevant individuals, what did the subcommittee, and what was the relevant allegation and specific provisions that are being alleged to have been violated, and what did the subcommittee conclude? In other words, why are we here? Just to basically set the framework so everybody understands this is the case we're thinking about, so that when the Inspector General then comes and gives her presentation and opens herself up to questions and or her designee, it's clear to everybody this is the case that we're thinking about, and these are the questions that we have. And you can then lay out again what you might have expressed previously, which is that these are the concerns that the board had regarding this particular investigation that we want to have more hearing on. You would then turn it over to the Office of the Inspector General. The chair would then recognize the Inspector General or the designee and request a presentation. That would be up to the Inspector General in terms of what they think would be most appropriate to present to the board. That would be, and that's something very much that Tiara will end up working with her clients about what makes the most sense. If you're interested in a specific aspect of the particular matter, then they're probably going to focus on that matter. They're going to talk to you about what their investigative process was. Who did we interview? Why did we make that choice? Those kinds of things, and it's really going to depend upon what the issue the board has with a particular investigation or the clarity that you're seeking. When they're done, they'll then yield back to the chair, and the chair will then open up the matter for discussion to any of the members of the board. Each one of you should have an opportunity. You don't all have to speak, but have an opportunity to speak in the event that you have questions. Think about it like a congressional hearing, where each one of the members of the committee has the opportunity to have a period of time where they can ask questions. They can waive that time if they have no questions, or they can defer. But then those questions should be directed towards the Inspector General. And then at the end of the day, then there's going to need to be a motion. And so there's going to need to be a motion. The motion is generally stated in the affirmative, which would mean that the motion would be to accept the recommendations, even if ultimately the board is intending on voting them down, because after the hearing you've decided, no, we don't accept them, right? It's usually still, I don't know why that is, but it is, that you make the motion in the affirmative. So whoever does feel that it should be recommended makes that motion, and then you continue the conversation about why you agree or disagree. You can modify it. So sometimes there are recommendations made, and maybe there's multiple allegations, and you agree with 3 of them, but not the 4th, right? That's another thing that can happen. And you could have all of those discussions. And then at the end of the day, you take a vote on the motion that's then pending before the board and you can break it down. We want to take a vote on recommendation number 1, if there are multiple recommendations as an example. So all of those things are just the normal things the chair has to think about in terms of, I know.
Chair has a headache.
I know. But that is how a full hearing would be conducted. So I'm laying that out. So the question is now each of your subcommittees have done your initial review. So, the next process would be for this board to then have the subcommittees report out to the full board with what they have, and then for the board to discuss what they ought to do with those recommendations and how to move forward. And if you decide that there's one that's particularly contentious, then you would set it for a full board hearing, notify the Inspector General that you want to have a full board hearing, notify them what the areas of contention are so they know how to be best prepared to answer your questions, and then we'll see how it goes.
out of all of the options there, one that you mentioned was that issues could be resolved literally by hearing from the Inspector General, right? So this is, would be my concern. I know she reviews them all. But if I was her, I could not say I could come in here and have the deep information on 30 different cases. So I'm just going to, I'm not looking for an answer now, but I would say to Attorney Ross and to the IG, I think you might want to consider having the investigators in this room on days that we are seeing, so that the Inspector General might be able to turn to her investigator, to whatever, to clarify. I just don't want to see her put on the spot of not being able to respond because she's got 30 cases.
And we've already discussed this, and the actual investigator for the case that is going to be heard will be here.
But I think Chair Jackson, is talking about at the time when the board's first considering it for a full board versus at the full hearing.
So it's not a hearing.
Right.
The matter could be resolved. What the question that might come up from the review committee
Gotcha.
Could just be resolved by a verbal clarification. That's, and I'm going to also say, I think since we are all in this now, the very beginning, I think that your staff, this could be helpful to them, even what was presented today. So I know it might be taking them away from 3 hours of their work, but this presentation, I think, is just excellent. I think the questions coming from the board members might also inform the investigators in terms of their work. So just something for you to consider. I'm sorry.
Just like 5 minutes before we wrap up today to actually initiate a complaint. So I just wanted to make sure that you.
I'm sorry, I'm not
Can you set
understanding.
5 minutes aside before we conclude today so that I can initiate a complaint? And put it before the board for a second?
So that you can initiate a
Yep,
complaint?
yes, ma'am.
That probably is going to take more than 5 minutes.
Not if we just
No,
vote really
because there has to
quickly
be a
on it.
discussion on a vote. I mean, the board has to vote before. Okay. Let's talk at break.
Okay.
If we ever get to break. Yes.
If the board has any questions for any reports that were submitted, if we're able to get those questions ahead of time, so even the fact that we know there's a lot of investigations out there, the investigators, again, are not going to know everything because we have a lot of cases. So if we know those questions ahead of time that the board would have questions for, that way they can be prepared so when they're here, if the board has any questions, they'll be able to answer those questions.
Madam Chair, it might be the case that we really are not, in general, talking about 30 or 40 cases, since, the vast majority of cases, the subcommittees would be in agreement with the Inspector General.
We don't know because we haven't been there yet.
Yeah.
I mean.
I'm just talking about the best
You
subcommittee,
have a
though.
very, you have a very
best subcommittee
positive
did.
attitude,
I'm
and I
very
agree with
confident.
you, but until I get through this, I'm not coming to any conclusions.
I think at a certain point, and we're learning and we're walking through it, getting a tiered system in place so that you're not, not everything needs to rise to the level as was just discussed. And then even still thinking about, even kind of modifying our checklists a little bit to make sure that the most, maybe we have some sort of logic chart. Okay, if we disagree, then we're going to ask a little bit more detail and dig deeper here. And then figuring out a process that we have, whether it's directly through you with the Inspector General's office or thinking about getting this information ahead of time, just the minor questions that we might have around details, standardizing, because that was some of the things too, is just like more standard setup. So we're going to work through it. But I am part of the public hearing question that I do have.
Yeah.
And I know there's like 8 parts of this question, but if there's an appeal process or something, I feel like we're doing a hearing, or we're talking about potentially doing a hearing, and yeah, so I'm sure you're going to get to it. But I just had
There's
that
not
question.
an appeal process. So there's not an appeal process only because we're only one step along the way, and the officer's potential appeal process happens once it hits back at the chief of police.
What about the complainant? Do they have the opportunity to appeal a decision?
They do not.
Okay, and so a question on that front, just for the civilian review board's procedures or within the law that we have. I mean, if somebody disagrees with a decision, or I'm just, what recourse or what opportunities do they have? Is it the public here?
Yeah. Well, I mean, I think the
yeah,
thing is
okay.
that you're here to represent the community, obviously, and individuals. Not everyone's going to be happy. You're right. But at the end of the day, it's a recommendation and it's an advisory board, and so there isn't generally an appeal from an advisory opinion because it's still going to go through the rest of that. In terms of what role you want the complainant to play or not play in your process, that's going to be up to the board. I mean, there's nothing specifically required of it in either the charter or the code or in your existing rules and regulations. If you want to consider having that, that's something that the board would need to discuss.
Okay, I would love to maybe discuss that at a certain point, because I think otherwise, at the time we get to review hearing, I don't know what more we can offer, add when we go back to the IG's office and say, okay, could you do a little bit more fact finding here, or we disagree, when we've already maybe contacted the complainant, it's already navigating through its process. It seems like by that point, some of this might be moot. I don't know. I'm just trying to get a sense of why we're doing that at that point.
While we're doing what at this point?
I mean,
I'm not sure I'm understanding.
So what I'm saying is, if there's no sort of a appeal process, the only kind of change that could happen at that point would be it goes back to the IG. We make the recommendation, something, if we disagree with a decision, for example, goes back to the IG's office, and then maybe you all would then agree with us or something, or make an additional determination. I just don't.
If you disagreed with the
an appeals process, because I think what you're just talking about right now is what we've been talking about. If we disagree, we send it back, provide the Inspector General's office the opportunity to consider bring it back to us. But they're just going to be, we're going to make decisions and forward them to the chief or the safety director that complainants are going to disagree with. And at the end of the day, there is not an appeals process from that end. The only option that I'm aware of for the complainant is to file a civil lawsuit. Because I think we're talking two different things. So if we are very comfortable with our decision that a complaining party disagrees with, they don't have another option.
Yeah,
And that's
I mean,
the appeals process.
Yeah, I mean, I guess I'm just trying to get a sense here where we're not just doing some additional double checking of the work. I mean, and just kind of moving things along. And that's part of this. But I think I just don't want to get into the situation in which we are, again, I'm going to try to say any sort of like micromanagement, but like doing so, we're only doing a certain tier of cases that.
You are double checking the work. You're putting full faith and confidence in the IG to do the investigation, and you are double checking the work. So that's your role and function. And in terms of the appeal, there is no appeal. And the analogy I can give you is when I worked at the prosecutor's office, I was in charge of the intake section. Victims came in all the time to file criminal, saying they were a victim of crime. We did our due diligence and investigated those, but only 10% of the time did we approve criminal charges on their behalf. That means 90% of the people went away upset. We still afforded them community resources. We tried to help them. We made referrals to other agencies that could help them, but they were not happy with our decision-making, but that was the decision.
That's why it's so important to let that civilian witness know. They voted for us, and let them know that this is what we decided. Even if it's the officer did not cuss at you. We did our work. We reviewed the body cam, and this is what we saw, and then that's it.
Okay, so
You know.
I'm going to use the prerogative of the chair. We're going to move forward. so we can finish up your presentation.
I'm done.
Madam Chair. Madam Chair, I just want, I'm going along with you. I think that if we have pertinent questions, just for the sake of time, let's take a pen, write down your question, and at the end of the presentation, we can ask all of our questions.
I actually am done. So,
Are you finished?
I want to actually sort of speak to Jackie's point, though. Why didn't her team already have all of these? I got mine done like the week of, after I was provided these. So my review sat for 3 weeks, not either in with you or with her. And to me, that's why
Your
I came.
review was to be discussed, it's your review. You are part of a 3-person committee.
Right.
The 3 individuals are to come together, you discuss it amongst yourselves, and then you come up with recommendations that you can agree to.
Right.
Not your individual ones.
No, I know that. I understand that. I'm wondering why she came today without the
She who?
investigators, that she needed to
that's-
bring to
that-
speak to the ones that,
Okay.
for.
to the Inspector
Yeah,
General?
the Inspector General. Because you came in, you said
IG Henry.
some folks, yeah, IG,
Okay.
yeah.
Make sure we got her name.
Yeah, absolutely. I'm sorry.
Formal,
The
thank
last
you.
name? The last name?
You can say Inspector General, you can say Inspector General Hendricks, but we are going to afford
Oh,
her.
the formal.
Yes,
I apologize.
formal.
I apologize, IG. I'm just wondering, why we're not discussing these and moving forward with the, which I believe that after this presentation, we were going to be then presenting our,
That was the plan.
That's where the discussion is.
Go ahead.
I mean, that was my understanding, that this was helpful for us to really get an insight on kind of the law, what kind of boxes us in and what we have, what authority we have. But beyond that, I think that's later on down the agenda in terms of kind of the questions that we have. Again, I mean, this is the first time we're doing this, right? So I think we're trying to figure out the best practices, like we're trying to figure out the questions. That's why I had questions around appeals, right? However way we want to talk about it, like how we posit ourselves with a broader community, whether it's referring people to resources or who does that, right? We can think about that, but that's your specific question, I think, is a little later on to, I think, maybe part three here.
I'm just saying that for the sake of, for getting through this a lot quicker and stuff, when we don't have the presentation obviously right in front of it, I get that.
We haven't even gotten to any presentations today. We've not reviewed a single case today. So
We're not
again,
going to review any cases today?
Pardon?
Did you say we're not going to review any cases today?
That's not what I said.
Oh.
Up to this point, we've not reviewed a case.
Okay.
We've had, again, and I want to thank you so very much.
it's all right.
No, I do, because I think it's unrealistic to think, this is very detailed information. It's hard for me to retain it all from how many months ago. It was a good refresher. We will have others. Excellent questions have been raised by the board in terms of how we move forward. Are there any other questions to our general counsel about the presentation? Just sticking with that, what she presented.
Just at the public hearing, I mean, let's say at the public hearing situation, let's say a complainant comes to that public hearing. I mean, in terms of figuring out, I know this is kind of a standard procedure thing or whatever, but in terms of any recommendations or thoughts you might have of how we set up that process so that it's maybe not an appeal, but there's additional opportunities to speak.
So again, that's
possible.
going to be, and I would leave it to the chair in terms of determining how best to make those decisions. But I will say that there are other boards and commissions that will hear from, for instance, like an applicant in the BZA will be able to come in and present their case. But it's a little bit different here in the sense that you don't have a person who is coming forward and saying, I specifically on my own behalf want something from the city. Instead, you're talking about an employment action and a person who's indicating that I feel I want to file a complaint against an employee who I feel didn't do something appropriate. So some of the other boards and commissions may not be the best model because that is different, right? But it's up to you. I mean, what would you like to do? And I would think in answering those questions, you want to think about volume. And then this is the one when we were having this conversation informally, the one that I really want to make sure everybody is aware of. So as you thought through your subcommittees, you've had a number of them that you felt everybody agreed with the Inspector General, right? And so the idea would be that you're going to come forward, you're going to vote as a full board, and it's going to move on, either to the chief or it's going to be closed out, whichever way it is. Are you going to notify every single victim for every one of those? And if your determination is going to be, well, no, because we all agree, then why are some victims going to have the opportunity to come at a full hearing and present, and other victims who feel that they've been victimized are not going to have that opportunity? So it's something that I think the board needs to discuss and need to think about who's going to provide notification, what kind of process are you going to be able to have so that you, like, how would you be able to notice somebody now for January? Do you know who's going to be before the board in January, which cases? So you want to think about, there's an entire administrative process that you would have to develop if that's what you wanted to do. And so I would leave it to the board. It's within your discretion to make that call.
And that's helpful. And I think if we get to the point where we're looking at patterns or things like that consistently, and it talks about policy or broader question, at least my personal thought would be that I don't think we getting inundated with every single step of every single case that we go through, but thinking about that tiered system so that it doesn't come to that, but we provide an opportunity for folks.
What do you mean by a tiered system?
I mean by...
So let me,
Yeah.
I've sent 10 or 11 cases to each subcommittee.
Yes.
Are you talking about within that subcommittee, you're somehow using a tiered process? No.
No, I'm saying that as a full board, and even thinking about with the Inspector General's office, like there are certain cases that either hit like excessive use of force or something like that, that hit a certain level that would be, I'm not saying more likely necessarily, but like that have, are part of the impetus behind the reason why you have the creation of civilian review boards that rise to the level of maybe further discussion and debate versus like, I trust that the IG's office, the investigators are doing their own review processes as well. And then we're doing like a quadruple check review process. But there are certain instances where I think being able to step back as a full board and say, when I'm looking at 10 cases, it's kind of hard to think about patterns. But when we step back and say there are multiple instances against multiple officers, whatever that might be, that's what I mean by tiered system.
Thank you.
A question to take us back to 2 civilian board meetings ago, but did we appoint you as like the chair of your own committee
That's right.
to like
That's-
research that stuff and then
that's the
send us
goal.
back like what that
And he
process
has
should
not
look like?
reported back to the chair.
That's the goal. It's coming. Just for the word, it's coming. It's on
He's
its way.
not reported back to the chair. Again,
Just a real quick note, for folks who haven't looked at it in a while, our rules and regulations do allow for public comment at our hearings in accordance with the regular city council rules for public comment, so submitting ahead of time, getting 3 minutes and things of that nature. So when you have a chance, pull them up again and just review them. We put a lot of time into writing them, and some of the things we've asked today are covered in those rules and regs.
excellent point. Okay. We are going to take a break. We're going to take a full 15-minute break. Actually, maybe even 18 minutes. We are taking a break until 4:15. I am adding a matter to the agenda. You probably heard in the regular meeting that board member Aragon wanted to present something to the board, so we've had a chance to have a conversation. He wants to present a matter, and then he is hoping that the board will vote to initiate an investigation.
I understand that I'm one person on this board, and I actually belong to an even more smaller community. But I came into this role because I wanted to actually be very representative of that community. And I don't really believe as a person that regardless how small that community is, that we don't deserve this, the exact same protections under the law. My community was terrorized this weekend by Proud Boys and hate groups that came to Columbus to disrupt an event sanctioned by a church, at a church, et cetera. Things have come out about the events that happened from the church itself in statements explaining the callous way that the CPD responded to their cries for help. So I also feel that there was even worse visuals for the CPD after the fact. We have Proud Boys and police officers high-fiving each other and joking around. I don't really need to have a great imagination to know what a Proud Boy would be joking about that they might find funny. So I would, if there is no actual investigation that's already been opened up with the IG's office, I would like to see if any of my fellow board members feels that this merits a second.
Well, in terms of procedure, the board has to vote to refer a complaint to the Inspector General. So it's just not a matter of having a conversation. That is the actual process. And I don't know, when we chatted briefly, I thought there might be a little bit more specificity around officers' names or et cetera.
They're all online. I mean, I can get them if you'd like, absolutely, and have that conversation more in depth.
There's some questions.
Go ahead, yes, please.
So, yeah, I mean, I think generally similar to the situation about the police-involved shootings several months ago, as a board, we kind of had a discussion about whether or not there are ongoing complaints or cases we would like the IG's office to initiate a complaint or review into the process. And I think, and I'm not sure exactly when it's submitted or when it's proposed from the board itself, whether it's a complaint or a review into a complaint or investigation into it. So I'm open to that. I'd be interested in just information on whether or not there's an ongoing issue. But from the topic itself, I do want to plus one the statement made and the importance of when these instances occur, that that we as a body, as a review body, talk about these issues and investigate and review these issues. And what we saw this past weekend was troubling and deeply concerning. And again, not going to comment on the specifics on what things look like, but this is a matter that either the board, I think, should initiate, or the IG, if they haven't already, to look into this matter. And I hope others, agencies responsible as well, will look into this as well if they have not. Thank you.
Let me ask the IG. It's my understanding that these incidents occurred on Saturday evening. It's only Tuesday, but I would like to know if the IG knows. Have you received any complaints up until this time about this incident?
Yes, Madam Chair. We have received at least 2, possibly even 3 complaints about this exact incident that Board Member Aragon is speaking about. At least 1 or 2 of those do name specific officers in them. So we do already have everything that again, Board Member Aragon spoke about. We already have complaints on those.
Okay, and I want to be clear, I'm not in any way trying to say that we shouldn't also initiate, but I just wanted to know if something had already, started. Other questions?
My question, and I wasn't sure what the board would be doing in addition. If I was hoping that complaints would have been initiated by individuals who had, some knowledge of the officers involved and also were affected by, this. So, yeah.
That was going to be my question as well. And if it was a no, then I was also going to ask, in terms of initiating, did we actually need to write it or reduce it to writing? But it looks like it's taken care of. So I'm all in favor of the investigation moving forward as it is.
So are you indicating that because the IG has already received at least 2 or 3 complaints, that, in your opinion, we don't need to move forward with our doing something?
That's my perspective. I know Gambit is the one that brought this up, but I think if the IG and her team already has 2 complaints and they're already opening up investigations, I don't think there's anything that we should do further until it actually comes to us for review.
I had a secondary question for the office, actually, in specifically, you said you had some officers that had already been identified, and one that am I to assume was more general in nature, and if it was very near, sort of general, did it ask for specific? And because I do believe that this was a failure systematically from the top coming down. So I would like CPD to be able to speak to, telling them that they could order a police officer if they wanted one, after the fact or whatnot. Like who is having those conversations with these community members that might have not escalated the intensity of it, I guess, maybe, to the right channels, I guess. So I get that is a little bit of and I'm, by all means, we're all chatting, and I want everyone to think about it. I'm also just a community member, and don't exactly know what that would look like or even mean for you to be able to take on such an entity like that, so, or work with an entity to find out and get the answers for the community that we want.
Just to be clear, you are speaking about the response or lack thereof at the drag story time incident.
Yep.
Yeah, so the complaint states
From Red
that
Oaks.
CPD was negligent in their response to a real threat against innocent people and children. And that's just one of them, but basically they're all in line with what you were speaking of.
I would also just add, I do believe the mayor issued a statement on the details, because I know you asked about that top-down approach, where he gave some additional insight on where, what had been taking place, and then some of the decision-making process in that. So I don't know if you had a chance to see that, but I think that gives a little bit more insight into that situation as well.
And I did not read it or hear it directly from her. I was just listening to the news, but I'm pretty sure that Chief Bryant also addressed this. But again, I can't specifically say how. It was reported on the news. Was there a press conference? I don't know about that. So again, what's the how does the board want us to proceed? Because I either need a motion to move forward in some way, or just a consensus that we're going to leave it with the IG with the complaints that she already has.
Well, I think this kind of gets into one of the questions that I think I had a couple meetings back around what the offices or the Civilian Review Board or the IG's offices, what their public response is during these incidents. Because again, when these types of incidents occur, there are responses from CPD, there are responses from the mayor's office, other city leadership positions. I don't know if the IG's office has issued any sort of responses, such as there's an ongoing or there will be an investigation or whatever that might be. But I think when these things happen, it seems like it takes a meeting like this and somebody who brings it up for us to know that and I know that like you're already looking into it, you're getting complaints, but I do think that as a board, just trying to figure out a way that we are proactive, that somebody's looking into it is a helpful step. As far as a specific action that we take or don't take as a board, it doesn't seem to be that we need to initiate another complaint. I do have some questions. I'm not sure some of the specifics of it, but I believe that they're into particular officers here about that complaint. But again, I don't want to go into the specific details as a review body, right? But those are my 2 cents. I just think some sort of public-facing statement or not on a set of things might be helpful.
I'm going to be having, and we haven't had one for a while, I have a meeting with the Inspector General within the next week or 2 weeks. And one of the things, I can give her a little bit of notice, I want that SOP delivered to me by Friday of this week. I don't care what state it's in. By Friday, 5 o'clock, delivered to my house. Okay? And I'll get a chance to read it because I don't know, for example, if in the SOP, if there's anything that would cover this, what we're talking about. And to me, it should be, right? In terms of the public speaking, the piece. And I'm going to try to recall all of the things that have come up that I think are really there, in that office, to cover. I may not be able to, but reach out to me individually if you want me to specifically address, ask questions, et cetera.
I just have one more question. If we were to take a vote to initiate an investigation on top of the complaints that have already came in, would that jeopardize our impartiality or give the perception as such, or would it just be as simple like we just want to know? Have that, because I know there was a vote taken, I think, on some other issues, but I don't believe I was at that board meeting.
I think the board meeting you're talking about was in August, so it was probably the September board meeting. There were 3 shootings by police officers. BCI has 2. The one was a discharge of a weapon, but no one was hit.
Okay.
And there, our motivation was to make sure that in case someone hadn't filed a complaint, we wanted to preserve that investigation.
Okay.
And so that's why we did, those 3.
Okay.
I would just speak to the impartiality. I mean, again, we are not investigating a particular situation, right? So just as a review, and that would be on the IG's office to specifically investigate. I do understand the importance of what does it mean when you initiate a complaint, but again, I at least in my inclination of as we would if we were to initiate a complaint, again, it's to really look into and investigate, and for us as board members to not have our own kind of impartiality or biases into that, right? That is something that the IG's office would look into. So I don't know if when we initiate a complaint from the board, we're not saying there's a finding here, X, Y, or Z. It's just we would like to review.
To the relationship between the IG and the public or the media. If I were to advise the IG about that, I would say because she is the entity actually conducting investigations, there needs to be very minimal contact. If there was going to be a public-facing body, this board is likely the most appropriate to do so. But I will take that under advisement and make sure we at least talk about it.
On pending matters.
My concern is if we already have an investigating arm, and there has been complaints, at least 2 already lodged, then why don't we let the process work? let the process work. And then if this board, in the completion of the process, if we're not satisfied, then we can go ahead and ask for further investigation on this. That's because I just don't want to see us, me personally, I don't want to see us put the cart before the horse.
But I think that goes into the public-facing side of it. There's limitations that the IG offices has because they're doing the direct investigation. So there's going to be some limitations that they can talk about or conduct with the public. The Civilian Review Board, as a review body, as a double-check body, we also have limitations because we don't know the specifics of a particular matter. But the challenges I have is that just that very point, we may not know for another 30, 40 days, but when these incidents happen in real time and people are concerned about what's going on and what the process looks like, they're going to look to all of the various agencies that have some sort of jurisdiction around this. And so I think it's important for us proactively to make clear that we are going to be on top of it, and the IG's office is going to be on top of it. That's something we're going to look into. So that's where I'm at on this. But as it relates to whether or not we need to take a specific vote on this, I don't necessarily know if we do, if there's already complaints. Again, we don't want to be in this situation. Now, again, we're learning for the first time what this might look like, but we don't want to be in a situation where, like, the complaints are, there's not much to the complaint or whatever, then it's like, oh, did we review? But my understanding is that IG's office, part of their work is going to be to dig deep into any and all complaints, and we'll know about that when that matter comes. But as a body, I do think it's important. All the other city agents, not that all of them, but a lot of major city agencies or electeds or others will say something. And I worry that us just saying we're not going to comment is
From my perspective, I don't even say I'm not going to comment. And if this needs to come before a vote of the board at some point, we can, because, Mr. Strickland, I strenuously disagree with you. I don't think we should be saying anything. I mean, we shouldn't be proactive. I've said my views before in terms of what our role is, but we're not the mayor, we're not the chief of police. We're this independent body that has been created to accept complaints and to review them. And I personally don't have a sense of responsibility to be speaking out to the public about what we're going to do. Now, as I said, so if there's a way that this can finally get resolved, and if it needs to come down to a vote, then please bring something. But that's the way. We've had very different views, and I believe on the board they're very different views. But if we need to get to some resolution of it, so that it's not coming up every time there is a significant case, then we need to do that. So, yes.
Chair, can I be recognized on this particular question? Because I just had one thought to throw out there as the board is considering its actions. The board can certainly have, as part of their board hearing, a confirmation that the issue is being looked at because it was raised as a concern, and that could be separate and apart from the board initiating a complaint. The initiating of a complaint raises the concerns that Chair Jackson's discussing about, because that presupposes that the board feels that there's something there that is to be complained about, and that can get into trouble then when you're subsequently reviewing. But certainly the board as a public body can say, hey, I've heard things, so as a board, I've inquired of the IG, they've confirmed that they're already under review, and so the board's action was the confirmation that somebody's taking a look.
In this situation, I saw on TV that high-level officers were high-fiving one, and then I was watching the TV, and sometimes I don't hear everything, but the chief spoke on this, and I don't know if it was what it was, a conference, but she seemed to defend the actions from what I saw. So do you see as there being an issue here or not? Or
I think that's what the Inspector General is going to have to determine. Because
okay.
you have seen slices of things that
Yes.
occurred, and what we don't know at this point, and it's not before the board, is what was the chronology of those things? What was her defense? Was it of that action or of the action of the division generally? What were the conversations before? There's a lot of things that did or did not happen during this incident, and I think that that's what the Inspector General is going to be looking into.
Yeah, this is very important, I think. And
I guess the reason I even brought it up, again, it is my community, and to your point, if you're not really looking at the same news or getting your sources somewhere, or you have people on the ground that are experienced in this live, then it doesn't necessarily get out or get the traction that it needs. But I think that's the beauty of this board. We again, like I said, I'm by myself on this, because maybe this is just how I am, that's my niche, right? And who I'm here to try to elevate. But other folks on this board have other experiences, and you will also see terrible things happening out there. So it's, see something, say something, kind of, that's sort of how I understood, what I just did. Whether I agree with the judge on voting on making it a case, it sort of makes it sound like there's sort of, we have a vested interest in figuring something out or another. I sort of envisioned that next I would not be getting this case as a review, obviously, because I'm the one that brought it forth. So, it wouldn't be in the three that my team would be like going over, but someone else would be, looking that case over and presenting their findings on whether they agree with the IG or not. And then at that point, I think, right, wait, no, that was it, right? Yes, that was it. And then we're done. I was trying to see if I got that assignment right.
The chief of police did make a statement, and I don't have her transcript in front of me, but it was a recorded statement that you can go back and watch. But I wouldn't characterize her words as defending the division. Also, I just wanted to reiterate that if the IG already has 2 complaints in front of them, is that correct? And then they're opening up an investigation. I think we should just let them do the work, and then when it comes to us for review, we can review that case. But that's just my perspective on that.
Just for clarity, cases that are opened about the same incident end up combined. Is that correct?
Unless there is some additional information that needs to be added that we don't already have, any complaints we have that are very similar are combined into one investigation.
maybe that's a good idea. That I saw, it was disconcerting.
IG, would you be able to explain how far that investigation, in my head, I see it sort of as a tier going up, right, on who you can ask questions of, et cetera, et cetera. So if in one of the 3 complaints that you do have, someone mentioned the mayor, someone mentioned the chief of police, would those folks, for one of your investigators, would those folks now be, asked to maybe give, have an interview about, findings or whatnot, or why they decided to do, I guess I'm curious as to what kind of a reach we have in that sense for the community.
So I have not had a chance to look at the total allegation, but what I try to always say is that our jurisdiction is over the Columbus Police Department, so we would be investigating any type of misconduct that occurred involving the Columbus police officers.
We've got a couple of critical decisions to make in the next 13 minutes, so we will not be reviewing any cases today. So this is the situation. I think we have about 30 cases pending for review, and I have a brand-new stack of about 30 cases that I was going to assign. It's crystal clear to me that we need another meeting. We moved our December meeting because it was so close to the holiday, the January meeting, to January 10th. I am guessing that since it's in the midst of the holiday season now, it would be pretty much impossible to schedule, He doesn't even let me get my statement out. That would be Pastor Nathan over there. It would be pretty much impossible to get a meeting scheduled between now and the end of the year. So what I'm going to ask you to do, and just give me some quick feedback, is whether or not you think it might be possible for us to have a second meeting in January, the week of the 16th. So that's immediately following.
Chair, may I?
Or if you have other options,
I
please
have
do.
another option.
Yes.
And that is, well, two thoughts. Number one, I know with our committee, I don't know about the others, but I can say that with our committee, I really don't think our committee's review of the 10, or how many cases did we have?
I think each had about 10.
About 10. I don't think it will take more than 10 minutes for us to present to this board,
For
honestly.
all 10 cases?
Yeah, yes.
Okay,
Absolutely.
I heard what you said, so let me turn to the other chairs. Mr. Strickland? Without your going into a lot of detail, but just as you look at your 10 cases,
I
do you have
don't, I mean, I
cases
think
that you
there's, it's going to warrant further discussion. There might be things that warrant further discussion, but as far as the cases themselves, I don't, they're not particularly complicated beyond 10 minutes. I also am going to be out of town January 10th, or whenever that day is. But I will say that as it relates to presenting these cases, we can do it.
Okay.
We can too.
All right. So we're going to go with, right now, we're going to have a meeting in January. And then what I need to do publicly is to assign cases. Because what I will now do will be to assign to the subcommittees the new cases. Is that acceptable?
Yes.
That is acceptable. I think there are still some process questions that would be helpful for us to maybe via email to get over, but that is acceptable. That would be fine.
Okay. To the subcommittee chaired by Mr. Strickland, and I'm not going to do the 2022. I'm just going to go with the last four digits. 0160, 0205, 0201, 0220, 0305, 0337, 0360, 0371. Those cases are referred to the review committee chaired by Mr. Strickland. The review committee chaired by Pastor Nathan, 0193, 0183, 0209, 0239, 0331, 0335, 0361, 0374. And finally, the review committee chaired by Mr. McIntosh, 0164, 0175, 0215, 0304, 0333, 0356, 0364. We will review to make sure I have all of the numbers and to confirm. And we'll do this the way we did it the last time, assuming that your wishes are still the same. Before, except for board member Aragon, the board members only wanted to receive the investigation reports that are assigned to them. Board member Aragon wanted all of them to be sent to him. Is that still the case? Yes, okay. I would ask you, because we all know kind of what the holiday season is like, I would suggest that very quickly, chairs, that you reach out to your committee members to establish the date that you're going to get together to review these, get that done, now. A reminder that once you've chosen your date, time, and place, please get that information to Bethany. Also, in terms of the review sheets, Each committee will have one completed review sheet for all of their cases, or a review sheet for each case, I guess is what I'm saying, but just one, not three. Please get those to Bethany by Thursday, January 5. And the reason is that I do want to review those before I come into this meeting. And I hadn't been clear about that, but I do want to be able to read them and see them. Any questions or concerns about Yes?
We had some concerns about the review sheet itself, because we felt that there was a couple of things that needed to be added to that, like non-applicable and things like that, because we had a couple of cases that there was some of the questions that are asked on the sheet. I just put NA on the side of it because it didn't apply to anything.
Was that, Matt, would you reach out to me? Are you in? Oh.
Our guys were gonna condense it.
Yeah,
Instead of add.
And so that was going to be why I'm the delay in terms of our team to get it over to you. Is I had some questions about what we send to you and if whether or not we can have a slightly more condensed version of things that, administrative closure, something that doesn't rise to the level where you need to go through each, so it's easier to review more efficiently. And for things that rise to a deeper level, getting in more detail. So that was my plan, to just give you a little bit more higher level summary, to a point. You were talking about condensing as well? Yeah.
For example, the findings, instead of having to write them, how about we have a Dropbox for those specific findings and then check one or two if it applies, something like that.
Okay.
But we can have a meeting or whatever,
Okay.
because I got.
Just a moment. No, I mean, I'm hearing concerns from at least two of the subcommittees.
It's not even a concern. It's like, as a subcommittee chair, I'm just going to make the determination, slightly tweaking a little bit, but not going outside the bounds of like getting the investigative review sheet of certain cases that aren't require every single box to be checked in that way. I'm just going to give a more higher level summary unless our team, disagreed. But the things that we agreed on, it's just going to be a quick summary.
So why don't we do this? The checklist is a guide for us. And so for this next set of cases, within the committees, use your discretion. Even if you literally want to just put, NA or, whatever. Let's use your discretion for the next group of cases. Then hopefully we can have a conversation at the next meeting to see how that works.
Sounds good. Thank you.
Can I offer a suggestion? The ones that are coming back that are not going to have any issues and no one's really going to be, the ones that are coming back that are not going to have any issues and no one's going to actually have any problems with, is there a way that Bethany can just send those on over? Then the Thursday day can only be for the ones that are actually going to be discussed that next Tuesday, right?
We have to vote on each case.
Oh, that we're, okay. But I thought we were going to present for ourselves first and then
Well,
we
you're going to
vote.
present at
Yeah.
the next board
the next
meeting,
one.
and then we're going to vote. What were you sending to Bethany?
In the future, for future meetings, can like the 10 that we just got assigned, when I am done, when our team is done, and we send our one over to Bethany, can she just go ahead and forward those over to the IG at that point, because they're so close? They have to go through you? Okay,
They come to me.
all
They
right,
don't go back to the IG.
right. So do you send them to the IG at that
No.
point, right? No?
No, we discuss them here and we vote,
Okay.
even if it means sending it back. But we don't just, now, we've said today, if you have a question, et cetera, you can reach out, but not just sending your completed forms back to the IG.
Not what I was asking.
No, I think as a practice, we can, obviously, when we present as subcommittee chairs, you can skip over the ones where there's not much debate around. But we still have to vote on each individual case, and they go through the chair, and then that actually goes on to the department. So unless something needs to go back to the IG, it wouldn't otherwise. But. It's not even 5 o'clock yet.
May, the chair is requesting a motion to adjourn.
Second.
Second? All in favor?
Aye.
Motion, meeting adjourned. I'm glad Mark flew home.